When you find yourself involved with DHR, at the end of their case, they're going to send you a letter that says you're either indicated or you're not indicated. That's DHR terminology, meaning you're either guilty or you're not guilty of what they say you've done. And if you are found to be indicated for child abuse or neglect, obviously that's not something you want to stick on you for the long term. And so you really must file a written request for what's called an administrative record review within 10 days. It's a very short time frame. So if you get that letter, you should contact us immediately because we can send out a letter the same day requesting this administrative review for you. That means it's going to go to Montgomery's state DHR office and have them look over the case to see if there was sufficient evidence in your file to indicate you for what you're accused of doing. Now, if you work in certain professions, like in healthcare, like in childcare, or other certain professions, you are not just entitled to a record review, which is basically where a DHR committee looks over it. You're actually entitled to an administrative law hearing, which will feel a lot like a trial in front of a judge. It just happens within the DHR system with a person who is appointed as a judge for that case, not a formal district judge. And so we have often gone to court on these DHR reviews for an administrative hearing and had a trial where it gets overturned either because the workers are no longer available or there's not sufficient evidence in the file to convince that administrative judge that you are actually guilty of what they say you've done. So either way, if you are found to be indicated by DHR, you need to contact a lawyer as soon as possible to make sure that you meet the time deadlines to request either your record review or your administrative law hearing. If you miss out on that 10-day deadline to request this record review, then that indication is going to be part of a permanent record showing that you've been indicated for abuse or neglect. Unfortunately, even people who are not indicated will go on a registry showing they've been accused of abuse or neglect of a child. And so if you especially are indicated, you have to request it immediately because if you don't and you miss out on that, then forever, whether you're trying to get custody of a child, whether you're trying to get jobs in healthcare or with children, anything that could have to lead to what they call a CAN clearance or a background check through DHR, that is going to stick on you. And it's very, very important to make sure you request this record review or it's on you for the long term. If you find yourself indicated by DHR for abuse or neglect of a child, and you feel like you've been wrongfully indicated, there are certain reasons you may want to request a record review or even administrative hearing about your situation. Some of the grounds may be that you were told you failed a drug test, but you know you were not using drugs and you know you should not have failed a drug test. You need to, of course, immediately go get a new and separate observed drug test to show you were in fact clean at the time they said you were dirty. Or if the time has passed, you may get a hair follicle test to show you were not using drugs. If your home, they say, was dirty, but maybe the reason it was cluttered was because you had a mold problem, you're cleaning your house up, or you've just moved in and there's boxes everywhere. Just keep in mind, anything that's gone on in your home that you feel like you've been wrongfully indicated for abuse or neglect by DHR, you should absolutely request a record review or even this administrative hearing if you would qualify for that. If you want to request a record review of DHR, then at that point, what you do is you contact our office. We send a letter to DHR that lets them know you dispute this and you want this record review. They then will send it from this local county office to the state office in Montgomery, and they will review it. Now, sometimes that comes back very quickly. Sometimes that takes a long time, and we're talking 6 months I've had them take before. So you have to be patient, and eventually we'll get a letter back from the state DHR department that tells us either you are still indicated or they did not find sufficient evidence in your file to indicate you, and your indication has been overturned. That's what we want. And so it's going to feel like there's a lot of hurry up and wait along the process, but it's absolutely worth it rather than just sitting back and taking a DHR indication on your record. If DHR has been involved in your life and you feel like it was either vindictive or you feel like, hey, the caseworker had it out for me or that they've done me wrong and I should not have been indicated or I shouldn't have been involved with them. We get calls all the time from people that want to know, can I sue DHR for the damage they've done to my reputation or for the stress they put my family under? Sadly, you probably cannot. There may be lawyers out there that will tell you they can. That's not what our office does. We believe that the best option is to get through with DHR as soon as possible and to work to get your children returned to your home. Our goal in our firm is to make sure your children are back in your home in a safe and appropriate environment as quickly as possible. If you find yourself involved in any stage of DHR involvement, whether they've just called, said they got a report, they want to talk to you, or maybe they've placed your children in a safety plan with a friend or a family member, or maybe there's the extreme step where they filed for custody and you find yourself faced with a 72-hour hearing because they're trying to take custody of your children and put them into foster care. All of those options are scary, and you need to talk to a lawyer who's experienced in handling these cases, as our firm does throughout the state of Alabama. We know DHR's policies better than they do. We have successfully worked throughout the state to have children returned to the custody of their parents, even often at that 72-hour hearing. So we'll work with you to help you get your case wrapped up as quickly as possible. Reach out to our office today, and we'd love to talk with you about your options.